Hello friends, in the series on the income tax cases, today we will discuss an issue which is related to section 50C. As all we know that section 50C gives a power to the assessing officer to make the addition into the income of the assessee on the basis of difference in the stamp duty value and the sale consideration of the assessee if the difference is more than 10%. The question before the Jaipur ITAT SMC bench was that if the assessee is able to demonstrate that the assessee was not able to sell the property at the market rate, at the fair market value, due to some disadvantageous factors into the land, so whether in that case the assessee can take a escape route from section 50C. This issue has been decided by Jaipur ITAT SMC bench in the case of Ajay Kumar Jain versus Income Tax Officer, and this case is reported in 129 ITR Tribunal at page number 157, and the date of the judgment is 9th August 2023. The present case relates to the assessment year 13-14. During the previous year relevant to the assessment year 13-14, the assessee has sold a property, a land, and the sale consideration was less than 25% of the stamp duty value. The learned assessing officer issued a show cause notice. The assessee presented a valuation report given by the valuer, which was taken before the agreement to sell was made by the assessee, and according to that valuation report, the value of the property was 25% less than the stamp duty value due to a pipeline going through the land of the assessee. That valuation report also mentioned that the pipeline was protected under section 9 of the Petroleum and Mineral Pipeline Act 1962, and the valuation report also mentioned that the state government has also put some restrictions on that land, like the assessee cannot have any construction in the 5 feet area of both the sides of the pipeline. That is to say that the assessee has to spare the 5 feet from the pipeline, and it was the duty of the assessee that the assessee should not allow to grow something long at the side of the pipelines. So according to the valuation report, due to this disadvantageous factor, the valuation of the property or the market value of the property was less than 25%. But the EO was not convinced with that valuation report, and he made the addition. When the matter came to the CIT appeal, the CIT appeal referred the matter to the DVO. The DVO admitted that there is one gas pipeline which was going through the land, but according to him also, due to this pipeline, there was no disadvantageous position for assessee, so he upheld the order of the assessing officer. When this matter came before the tribunal categorically said that in the present case, the assessing officer, the valuation officer, and the CIT appeal has grossly failed to controvert the findings that due to the pipeline, the assessee was in a disadvantageous position to sell the land at the fair market value. The tribunal said that in the present case, the pipeline was protected under section 9 of the Petroleum and Minerals Pipeline Act 1962, and the assessee was having the restrictions to use the land. That is, he has to spare the 5 feet on both the sides of the pipeline, and it was his duty not to grow anything long alongside the pipeline. So due to these factors and from the facts of the case, since the assessee has taken due care and concern in selling the property, so the revenue cannot take the undue benefit of this due care taken by the assessee. And from the facts of the case, if there is a 25% reduction in the sale consideration due to the gas pipeline going through the assessee's land, so in that case it can be safely said that the section 50C provisions will not be applicable in the present case. At the end of this video, once again I am repeating the name of the case. The name of the case is Ajay Kumar Jain versus Income Tax Officer, and this case is reported in 129 ITR Tribunal at page number 157, and the date of the judgment is 9th August 2023. Thank you friends.